Okay. Good evening, friends, and welcome to this webinar on opportunities in the gift city, more effectively focused on the interest of the audience that we have today, that is AIFs in the gift city. Before I start my presentation, let me thank IVCA for organizing the webinar and giving us an opportunity to present before the attendees. This in the webinar, we'll be discussing upon various issues in relation to the IFSC. What are the activities which are allowed to be carried out? And a significant portion of the webinar is focused on AIFs, considering the interest of majority of those attending the webinar. Any questions that you may have, it will be difficult to take up questions as the webinar is going on, but maybe request you to put in your questions in the chat box, and we shall be happy to answer those. Those questions which could not be responded either due to paucity of time or the question not having come through, may I request you all may either email those questions to IVCA or to ELP. ELP coordinates will be there in the last slide of this presentation. But thank you very much, and let me start with the presentation. So as we talk about Gift City, and within Gift City, we talk about IFSC, International Financial Services Center. The important point is that the concept of IFSC is not new globally. Globally, IFSCs have been set up, established, and effectively been running for over some time now. In fact, if the IFSCs were to be categorized, we can say that there are three different categories of IFSCs. You have IFSCs which are in economically better jurisdictions like Tokyo, London, New York, etc., which IFSCs are considered in a way self-serving IFSCs. And when I say self-serving IFSCs, the economy in those countries is so highly developed that the economy itself funds for the IFSC to be operate, and the funds coming into the IFSC through the economy itself. The second category of IFSC would be hybrid IFSCs, places like Singapore, etc., where a significant portion of the funds in the IFSC comes from the home jurisdiction, that is from the economy itself, whereas there is a lot of external funding also which comes in. And the last third category of IFSCs would be those which are typically established in a weaker economy or smaller economy, say for example Mauritius. However, the IFSC functions quite effectively since various incentives, tax benefits, etc., are granted by the government to make the IFSC effective. So that's how the three different categorization of IFSCs exist. India has set up its IFSC in the Gift City in Gujarat, which is the first and only IFSC in India. We'll be discussing on then. Moving on to the next slide, Pranav, if you can change it. What are we intending to discuss today? We'll be discussing upon a bit of the background of IFSC, how IFSC functions, who was the administrator of IFSC, who is monitoring IFSC. Then we'll go on to what are the key benefits of setting up operations in IFSC. Then a significant portion of this presentation is focused on AIF in IFSC, and we'll take up a bit of a comparative analysis that if you have an AIF which is an onshore AIF within the landmass of India, or an offshore AIF which is the foreign AIF, and you have an AIF in IFSC, how does each of those vary, and what are the benefits that you see in an AIF in IFSC? And lastly, on the process of setting up an AIF in the IFSC. Moving on from there, a brief background on the IFSC. What is an IFSC? IFSC caters to the customers outside the jurisdiction of the domestic economy. So basically, it is, as the name suggests, a financial services center, but financial services center set up to cater to the customers who are not within the economy, but outside the economy, but who have interest in relation to the underlying assets of the economy. And therefore, the IFSC caters to those customers in the form of financial products, flow of finance, financial services, which are across the border, coming in from outside into the IFSC for further investment, either into the jurisdiction or using the jurisdiction somewhere else. IFSC is envisaged under the Indian context is a jurisdiction that provides financial services to non-resident or resident institutions in any currency other than INR. Because if it is INR, it can be done in the landmass of India. This is from the perspective of it being other than INR. IFSC is set up to undertake financial services, like the name suggests, which are transactions that are currently primarily carried out outside India by overseas financial institutions or branches in relation to their through their subsidiaries in or with the Indian financial institutions. So that is generally IFSC. From an India perspective, in India, IFSC is approved and regulated by the government of India under the Special Economic Zone. So Section 18 of the Special Economic Zone very clearly provides for uh, the existence of IFSCs in certain service SEZs. In view of that, a multi-service special economic zone was set up in Gift City in Gujarat, and we had our first IFSC being set up there. From an India perspective, the whole motto or the purpose of IFSC is to bring back or bring financial services transactions relatable to India back to Indian shores. We will be touching upon this, and this has been the underlying theme on a lot of legislation, a lot of provisions which have been brought in. And as we go through discussing on some of the aspects of IFSC, I'll touch upon this, how this is very eminent and clear, is the government's attempt to bringing back to Indian shores financial service transactions which are relatable to India. The scope of IFSC is typically, as I've said, financial services. Financial services have been defined as those services in relation to financial product. There is a definition of both the financial service and financial product. A quick view of that. Pranav, can you click on financial product, please? Yeah, financial product. So financial products are considered to be securities, contracts of insurance, deposit, credit arrangements, foreign currency contracts other than contracts to exchange one currency for another that are to be settled immediately, and any other product or instrument that may be notified by the central government. So the central government has kept it open to include, and very rightly so, due to the continuous innovation in financial products, technology, etc. Uh, Financial services has been defined as various services. There's a whole list of services. However, all of these services in relation to financial product. Yeah, if we go and have a look at the financial services definition. So it's a whole bunch of services: buying, selling, or subscribing to a financial product, or agreeing to do so, acceptance of deposit, and so on and so forth, safeguarding and administering assets, affecting contracts of insurance, offering, managing, or agreeing to manage assets consisting of financial products, etc., etc. Finally, again, within the listing of financial services also, there is an embargo kept open for any other services that the central government may intend to notify. And under that, in fact, very recently, the central government has notified global in-house services, global in-house, and they call it as Global In-House Services Center, GIC, which is an in-house outsourcing center of a large financial services group. So in case somebody wants to set up, a large financial services group wants to set up an in-house outsourcing center or an in-house support center, that can also be set up in the IFSC, and it will be considered as one of the financial services being provided. Going back to our original slide, uh, finally, one more aspect: IFSC unit is treated as a non-resident under extant FEMA laws, and it is very important since IFSC will be dealing, the units in IFSC will be dealing in currency, in foreign currency, finance, and a lot of flow of money across the borders. And therefore, typically, FEMA regulations come into play, and FEMA regulations at number of times were becoming a constraint in certain transactions being executed. By making these units as non-resident from a FEMA perspective, uh, these constraints to certain extent have been diluted. Of course, the authority steps in, and the authority would be monitoring to ensure that while there is monitoring, the efficiency of carrying out activities or executing transactions is not hampered in any manner. Moving on from a brief background of IFSC, what is the structural framework of IFSC? IFSC, as I mentioned, is set up in the Gift City, that is the Gujarat International FinTech City Company Limited, is the Gift City. That Gift City is an SEZ. Like every other SEZ, it has processing area and non-processing area. Within the non-processing areas, you have residential units, etc. And which what I intend to say is that there is a full-fledged infrastructure available for people occupying that location. In the processing area, again, you have the IFSC and you have the non-IFSC. So within the non-IFSC processing area, you'll have units which are captive units within the SEZ and which may or may not cater to the IFSC units. But within the IFSC, you have different units which are set up for providing financial services. So you have capital market services, you have insurance players, banking units. So of like you have OBUs, offshore banking units. Here you have IFSC banking units, IBUs, and various ancillary services units, including aircraft leasing, financing, etc. The recent budget announced certain benefits for aircraft leasing companies, and they have started setting up shop in the IFSC. Finally, within the non-processing area, you may have captive units which will cater to or may cater to certain other parts of the SEZ or cater to the IFSC units. Capital markets obviously will have the various fund-related operations also, and the typical AIFs will be part of the capital market entities to be set up there. Now, typically, all of these entities would have been regulated by their relevant regulators. So, for example, capital market entities or including others, including intermediaries, etc., in the capital market would have been regulated by SEBI. Similarly, insurance players would have been regulated by IRDA, banking units by the RBI, and any other ancillary aircraft leasing, etc., including NBFCs, etc., would be again RBI would have been regulating. However, recently, and that is in the April of 2020, there is a unified authority which has been created, the IFSC Unified Authority, which will regulate all of these IFSC units. This regulation being passed on from the normal regulatory authorities to the IFSC has become a significant beneficial aspect for these units in view of the flexibility of the authority as well as the promptness of the authority and taking various actions. And that has given a lot of impetus to the IFSC and the growth or increase in the flow of investments or setting up of shops by various financial service players into the IFSC. Uh, Moving on from the framework, structural framework, let us just have a look at how has the IFSC regulations developed. So 2015 saw the Ministry of Finance notifying the first IFSC in the country. Along with the notification, immediately SEBI also came out with guidelines. These guidelines basically touched upon how would stock exchanges, intermediaries, or even funds operate in a IFSC in an IFSC. Though the overall regulations would have still continued to be the original regulations. Thereafter, in 2016, we saw a few tax reforms being announced in the budget just to make the IFSC more attractive. And we also saw establishment of a few international exchanges, both by NSE and BSE, where foreign currency derivatives started getting traded. We had the setup of the Singapore Arbitration Center in the IFSC. IRDA came out with its guidelines to enable foreign and Indian insurers, reinsurers to set up shop. In 2018, we saw a significant impetus to AIF related regulations, and operating guidelines were issued in relation to AIFs by SEBI, which brought in a significant amount of clarity as to how AIFs can be set up and operated within the IFSC. Uh, 2019 marks a historic position when, in fact, in 2018, the finance minister, the honorable finance minister in the budget announced the constitution of a unified authority for IFSC called the IFSC Authority. However, the authority could have been constituted under a statutory diktat, and therefore the IFSC Authority Act was notified in 2019. Taking support from the Act 2020. And like I said, the 27th of April 2020 saw the issuance of a notification where the IFSC authority was notified. It was chaired by chaired by Srinivas Injeti. He continues to be the chairman, and the seat of the IFSC main office is the authority's office is considered to be Gandhinagar. Uh, Once the authority was set up, we have seen a significant quantum of announcements, clarification, circulars. Not just that, even regulations being announced, and these regulations have had a far-reaching impact on clarifying a lot of aspects. In fact, in relation to AIF, and we'll be discussing that a little bit more in detail, we've seen a number of announcements which have not only liberalized but eased the method in which AIFs can be set up and operated in the IFSC, making them a really attractive, making IFSC a really attractive destination for AIFs. So that has been the development of the legislation relating to IFSC in India. Moving from there, so the mother legislation in relation to IFSC is the IFSC Authority Act, which is the act under which the IFSC Authority has been constituted. Like I mentioned, 27th of April 2020 saw the MOF notifying the IFSC Authority as the unified regulator of all entities in the IFSC. The IFSC Act was passed to regulate the IFSC entities by the IFSC Authority. The IFSC Authority gets its power through Section 12 of the IFSC Act. The Section 12 provides its power to regulate financial products, services, and units within the IFSC with a sole focus of the IFSC Authority to develop these financial products, services, and units and ensure its effective development over a period of time. Section 13 provides the powers of various regulators such as RBI, SEBI, IRDA to be housed within the IFSC, and all of these powers will be now exercised by the IFSCA, which is the IFSC Authority, in relation to units which are set up in the IFSC. This is a very significant provision and creates a significant quantum of powers in the hands of the IFSCA. The constitution of IFSCA also therefore has nominees from an individual member from each of these regulatory bodies, which constitutes the IFSC Authority. In addition to that, there are two nominees from the central government, as well as there are two others from the IFSC itself. Section 28 is another important section of this legislation, where IFSCA Authority has been given power to set up or to frame necessary regulations to achieve the purpose for which it has been set up. In relation to this, and under this section, IFSCA Authority has issued a number of regulations, including the regulation in relation to banking units to be set up. We've seen regulation issued in relation to bullion exchanges being set up in the IFSCA, and there are a number of circulars, etc., which have been issued, circulars and guidelines issued by the IFSCA in relation to operation of various units within the IFSC. Section 30, another significant provision within the Act, provides that the IFSC Act shall have an overriding effect in case of inconsistencies between what is provided in the IFSC Act and other legislation, thereby giving a higher precedence to the IFSC Act. Section 31 again is another significant provision where the central government has been empowered to pronounce that certain provisions of existing central acts shall not be applicable to units in IFSC. And exercising that provision, exercising the powers under this provision, the central government has already issued various notifications, etc., where certain existing provisions under the existing central acts have stopped being applicable. Alternatively, the IFSC Authority has been brought in to become to hold the power in relation to various units that are set up in the IFSC. Lastly, various acts under which the different regulatory authorities were functioning have been modified to make it specific that the IFSC Authority will now be the unified regulator in relation to units which otherwise operate in relation to one of those activities. That IFSC Authority shall be the administrating authority in relation to those units set up in the IFSC. So all in all, the IFSC Authority Act, a significant legislation in relation to operation in the IFSC, creates a lot of power in the hands of the IFSC Authority. And using this power, IFSC Authority continuously comes out with regulations which regulate activities carried out within the IFSC. So that's the legal framework. Moving on from here, let us have an understanding of what operations can be carried out or what nature of units can be set up in the IFSC. So the first category we have is the banking units. Both Indian and foreign banks can set up their units within the IFSC. These will be either the public sector banks or private sector banks are authorized to operate in IFSC, and these will be known as IFSC banking units. All the dealings of these banks will be in foreign exchange. These banks will be regulated under IFSCA Banking Regulation 2020. In case of foreign banking units having presence in India, they will need to have a NOC from their home country regulator for setting up an IFSC banking unit. IFSCA banking regulations have been pronounced by the authority, and those regulations will be applicable as to the operation of banking units set up in the IFSC. From insurance perspective, both Indian and foreign insurers as well as reinsurers can set up base in the IFSC. The IFSC authority has not yet come out with regulations specific to insurance entities operating in the IFSC. However, the IRDA in 2015 had come out with IRDA IFSC guidelines, and those continue to apply to insurance entities, insurance companies having set up entities in the IFSC. Third is a category of capital market. Capital market related activities have been categorized under two sections, two bifurcations. There are core activities such as stockbroker, sub-broker, portfolio manager, clearing member, depository participant, custodian, credit rating agency, AIFs, mutual funds, etc. These are all core activities, and there are non-core activities such as underwriter, merchant banker, trustee, registrar, share transfer agents, investment advisor. Typically, all non-core service providers will be rendering services in relation to the core activities carried out by core service providers within the IFSC. The SEBI IFSC guideline of 2015, which I mentioned a couple of slides earlier, right now provides the framework in relation to how these different capital market participants will be playing within the IFSC. Next, very recently there have been the IFSC Authority Finance Company Regulations 2021, which have been announced, which provides for uh, regulations which govern the operation of finance companies and finance units. Finance companies and finance units have been defined within the regulation to mean companies or units, which is a branch of a company in the landmass of India, in the DTA, domestic tariff area of India, and which are carrying out operations, typically operations in the nature of core, non-core services as set out in the earlier bullet, and other NBFC related activities, which will be regulated by the IFSCA Finance Company Regulations 2021. And lastly, we have the Ancillary Services Framework, a circular set out which sets out the framework for enabling ancillary services for operating in the International Financial Services Center. Ancillary services would typically include legal, compliance, secretarial, and others, as have been put on the slide. So if it can be seen from here that a whole variety of financial services activities are allowed to operate within the IFSC. If we were to touch upon each of those, in fact, the regulations are also quite elaborate for each of those, and there has been a clear attempt by the authorities to, like I mentioned in the first slide, to bring back to Indian shores financial transactions which are carried out in relation to underlying assets or underlying operations in India. We'll see that very soon, but due to paucity of time, today we will be focusing on capital markets. If we move to the next slide, we will be focusing on capital markets and to certain extent on ancillary services. We do not have enough time to go through each of the other line of operations like banking, insurance, financial services, since elaborate provisions have been made available and there is a certain amount of bifurcation or the deviation which has been made from the normal regulations applicable to these units if they were operating in IFSC as compared to operating in the normal landmass of India. We have, however, touched upon some of these deviations for you all to just have a feeler of what is the deviation that has been brought about. So as I mentioned, IFSC is a financial services center set up in the landmass of India with a view to attract international transactions back to Indian shores relating to Indian operations. Uh, this could be possible only if the government provided an environment to the international players which is similar or closer to the environment in which they are currently functioning and operating. So therefore, over a period of time, the government realized that they realized the existence and benefit of various innovative financial structures, instruments, etc., which existed in other jurisdictions. However, considering the risk factors or the method of introducing those, implementing those in a proper regulated manner in the country, it would have been difficult to implement them in the whole of India. And therefore, IFSC has been identified where such instruments or structures could be implemented and under a rather relaxed operating environment and functioning of these entities could be possible. Therefore, if a banking unit, an IBU was to be set up in the IFSC, if a banking unit was set up in the normal landmass of India, it would be subject to regulations by the RBI. There would be applicability of CRR, SLR, the credit reversal ratio, etc. However, if such a banking unit is set up in the IFSC, the same CRR, SLR is not applicable. Rather, the authority has prescribed an LCR which becomes applicable. Having said so, at the same time, uh, since the risk factor increases to a certain extent, you will see that the regulations provide that the last lending resort, that is the RBI support, is typically not available in case of banking units which are operating in the IFSC. In case of reinsurance companies, again, just with a view to attract reinsurance companies, because most insurance companies in India are required to undertake a significant amount of reinsurance. GIC is the only Indian entity providing reinsurance, and therefore, significant amount of reinsurance is carried out by international players. To attract these international players to the Indian shores, the regulations for reinsurance companies to set up base has been liberalized. If a reinsurance company was to set up in India, in the landmass of India, it would require a net owed fund of minimum 5,000 crores. As compared to that, if it is to be set up in IFSC, the quantum has been reduced to 1,000 crores, clearly uh, indicating an environment being created for these reinsurance companies to be brought into the country and set up base in the IFSC. In case of stock exchanges, an Indian stock exchange could be trading in listing of rupee denominated shares and securities. In addition to that, every transaction on the stock exchange is subject to an STT. When the STT was introduced, it was clearly mentioned that STT was with a view to not from the perspective of collecting revenue, but rather from monitoring the transactions happening there. But at the same time, if a stock exchange is set up in the IFSC, it could list ADR, GDRs in foreign currency. In fact, it is dedicated to foreign currency transactions only, and no STT is levied on transactions executed in the IFSC. Again, making stock exchange in IFSC attractive, mainly for foreign exchange denominated derivatives and scripts to be traded on the AIF. In fact, AIF has seen a significant number of relaxation as compared to an AIF operating onshore. As compared to that, an AIF operating IFSC, we have discussed that quite a bit in detail in the subsequent slides as we go through the structure of AIF. Since the whole presentation is focused at AIF, we thought that at least for the other services which are or other units which operate in the IFSC, we'll touch upon some of the significant aspects. So net, what we are trying to say is that IFSC has been created as a jurisdiction which is regulated by the IFSC authority, which is an authority quite proactive and continuously on the lookout for innovative structures, avenues, etc., which are coming across in various parts of the globe, and trying to bring them into the IFSC, into back to India through implementation thereof. In fact, as we speak, we are aware that the IFSC authority is contemplating in relation to how to introduce SPACs and variable capital company related concepts also within the IFSC. So moving on from there, let's just touch upon what are some of the key benefits that units operating a setup in the IFSC will enjoy. Clearly, there is income tax benefit. There is a tax holiday for units operating in the IFSC for 10 out of the first 15 years. Capital gains exemption in relation to assets which are used by the IFSC units and then disposed of. Tax certainty, there are a lot of issues in relation to MLI GAR if activities relating to Indian operations are carried out from foreign jurisdictions. All that come to rest if the operations are being carried out from IFSC. GST, since IFSC is in the SEZ, the GST benefits are available to IFSC units. Companies Act, a number of relaxations have been provided relating to corporate social responsibility, internal audit related managerial remuneration, and other provisions which are otherwise vexing or rather affecting to certain extent the corporates operating in the country. SEBI, FEMA, RBI regulations have been liberalized to provide more flexibility. The Gujarat state, IFSC being located in GIFT City, which is located in Gujarat, the Gujarat state has announced various capital subsidies, stamp duty exemptions, electricity duty subsidy, lease rental relaxation, etc., which will all be available to units set up in the IFSC. Investor benefits will be available to units to investors investing into EIF funds in the IFSC. from the perspective of certain tax exemptions and non-applicability of STT, CTT, etc. Customs duty, again, IFSC being located in the SEZ, custom duty benefits as available to every other SEZ operations will be available to IFSC as well. In addition to all of these tax and regulatory benefits, important to note that the government has worked really hard to create world-class infrastructure and facilitation being made available in the IFSC with a view to provide the comfort and, for lack of better word, but enough luxuries also for people staying and operating or employed at the IFSC. So that's on the fiscal benefits. This is just a glimpse into some of the state subsidies provided by the Gujarat government, which I mentioned about. So there is electricity subsidy and electricity tariff exemptions, reimbursement of provident fund, contribution to employers, lease rental subsidy, capital subsidy, and etc. Uh, Moving on, we now bring our focus to alternate investment funds and alternate investment funds more effectively set up in the IFSC. And how are they different? How are they benefited? What are the regulations applicable to them? Let's look into that. So regulations governing AIFs in IFSC. Uh, AIF first started getting regulated by the SEBI regulation 2012 being introduced by SEBI way back in 2012. These regulations were directly applicable to AIF set up in the IFSC also post 2015 as and when the IFSC was set up. The SEBI IFSC guidelines 2015 was a generic guideline which covered stock exchanges, intermediaries, as well as funds, and certain provisions uh, similar to those provided under the 2012 regulations also got identified in the guidelines announced by SEBI. 2018 saw a significant impetus and clarity for AIFs operating in IFSC with the announcement of the operating guidelines by SEBI. SEBI issued the operating guidelines for AIFs in IFSC, which also brought in certain clarity as to who could be investing the funds, where could the funds of the AIFs operating in IFSC could be invested, and other aspects. 2019 circular was introduced for permissible investment by AIFs operating in IFSC. A certain relaxation was brought about and the avenue was expanded. So if there was an AIF prior to 2019, uh, the AIF investing outside, there were certain restrictions, etc. These were all diluted and therefore it made the AIFs operating IFSC much more attractive with the introduction of the circular in relation to AIFs and AIFs operating in the IFSC. Lastly, 2020, which is after the formation of the unified regulator, the unified regulator has now issued a circular enabling a number of relaxations and having far-reaching implications for AIFs located in IFSC. So the constitution of the unified regulator, the IFSC authority, and the announcement of the circular relating to leverage, co-investment norms, etc., which facilitate an AIF in the IFSC, has made AIFs operating in IFSC much more attractive as compared to other onshore offshore AIFs. We will be touching upon that. We'll be discussing in detail what are those amendments. But before we move on to that, two other aspects. Uh, the permissible investment routes in India for AIF in IFSC continue to be open. So an AIF in IFSC can invest back into India. However, it would be through an FPI, FPCI, or FDI route for which a registration with SEBI or IBI, as the case may be, would be required. So what is, this is a typical structure of an AIF, which is in normal Indian onshore AIF. The typical structure is that the AIF will be located onshore in India. The investment coming into the AIF will be the international investment. The foreign investment will be coming through a pooling vehicle or an offshore fund. There will be an offshore fund administrator or an offshore investment manager. There will be limited partners will be investing into the pooling vehicle, and the funds would then be invested into the AIF. Similarly, investments would also be coming in from investors within the country, and the sponsor of the AIF and the onshore manager of the AIF would be typically located within the country. This AIF then invests into various investee companies. Now, this is the typical structure for an AIF in India. If the AIF is an onshore AIF located in India. Now we compare that with the AIF, which is located in the IFSC. So you have the offshore region where the investors are located. You have the IFSC in between, where the IFSC AIF is located, and then you have the Indian investors. Both the Indian investors and the foreign investors invest into the IFSC and AIF. The sponsor of the IFSC or the manager of the IFSC are both also located in the IFSC. Uh, Again, carried interest is paid to the sponsor, or management fees is paid to the manager, as would have been in the normal course. However, as you see that there isn't significant distinction from the manner in which the AIF is constituted, still the AIF in an IFSC is becoming more and more attractive. And what is the reason for that? Let's look into that as you move to the next slide. The the relaxations provided to the AIF in the IFSC can be listed in this manner. So for an AIF located in the IFSC, co-investment structuring has been made possible. What is co-investment structuring? Co-investment structuring is that the investors, so say for example, the AIF has invested into 8 different types of investee companies. Typically, any unit holder would have equal proportion of interest in each of those investee companies. However, should one of the investor have a preference for a higher level of investment in a specific investee company, that could now be possible through separate class of units being issued by the AIF. That is co-investment structuring. So co-investment structuring has been made possible and facilitated by AIFs, where AIFs can now come out with what is known as segregated portfolio by issuance of separate class of units uh, for different investors depending on their interest and likeness. This obviously would be attractive for a certain class of investors and enhances the attractiveness of those AIFs for such investors to be investing there. The second effective relaxation that has been brought out, or rather than relaxation, or rather modification that has been brought out, is the investment sponsor or managing entity can bring in the funds under the automatic route. So investment made by an Indian sponsor or Indian party sponsor or managing entity in the AIFs in the IFSC shall now be treated as overseas direct investment under automatic route, and there, therefore there are no specific permissions etc. required. In a way, the fact that it has been facilitated under the automatic route also gives some sort of a cover from any allegations of round tripping should the funds then be invested into a foreign entity and further invested into an underlying Indian asset. More important, what is that it helps in expediting the process of setting up these funds in the hands of the Indians, the sponsor or the managing entity, and especially in these times where these are volatile times and the tapping of opportunity in a limited time frame is very important. This kind of facilitation comes up really handy and a long way in facilitating AIFs being set up in IFSC. The third one is the investment diversification norm. Investment diversification norm is basically ceiling up to which an AIF can invest into a specific individual portfolio company. The typical ceiling in relation to Cat 1, Cat 2 AIFs is 25% in any single entity and 10% in case of Cat 3 AIFs. Uh, However, this ceiling is not applicable for AIFs in the IFSC. Therefore, if you see that an AIF could in fact invest 100% of its funds into a single entity or a group, an entity group, which is in, I may not be surprised if there are a few AIFs which are set up with a focused fund to be invested into specific targets or a specific group, just with the view to identifying the investment interest into those groups. So this is another relaxation or a modification which has been introduced. Next, there is offshore investment. Uh, Typically, AIFs operating in the onshore AIFs, there is a ceiling on offshore investment to be made by AIFs. This ceiling is now removed in relation to investments to be made by AIFs in the IFSC, which means 100% of the investment can be made in offshore assets. Earlier, there was a restriction, only 25% could be made, but that now sits to be 100% of the uh, corpus available with the AIF can now be invested into the offshore assets. It facilitates in increasing the ambit of investment options and portfolio, and it also facilitates shift in strategy depending on the market conditions. So, an AIF which could have been fully focused and dedicated on a certain jurisdiction, on realizing that the potential of growth in another jurisdiction is higher than the prior jurisdiction, could take necessary steps if required to shift from one jurisdiction to the other. This may again be subject to the regulations in those jurisdictions, but assuming that those jurisdictions were quick enough to enable shift of investments, it would bring about a significant facilitation and help in the performance of the AIF. Lastly, a very important aspect is the ability to take leverage. AIFs in IFSC are allowed to leverage, that is, they are allowed to undertake funding through debt for investment activities. So far as the AIFs in the landmass of the country is concerned, Cat 1, Cat 2, AIFs are not allowed to take leverage. Of course, they are allowed to take certain 10% of debt, however, only to meet with their administrative expenses, but not with their investment activities. Cat 3, AIFs are allowed to take certain amount of debt. However, once an AIF is set up in the IFSC, debt funding is possible for even for undertaking investment activities. It facilitates in stability being available in the availability of funds, and more importantly, it can result into higher potential returns, and more effectively also a higher IRR can be showcased by that fund if it is able to invest in a manner such that the returns are higher than the rate of interest being charged by the charge on the debt which it has acquired. We've got a small modeling which we have put together in the next slide, which showcases there are three assumptions that we have taken. That let's assume that the corpus is of 100 million or a 1 trillion corpus, and the return on investment is 21.71% and the rate of interest is 10%. In that scenario, should there be should there be funding from the perspective of debt, say to the extent of 30%, then we are saying that the corpus goes down by 30%. The on the lesser corpus of 70 and the interest rate being at 10%, but the rate of return being at 21%, the same corpus provides a higher IRR of 26.72%. If the debt is leveraged further and the corpus is brought down to 40, I wouldn't say corpus, but the invested funds are brought down to 40, debt has been enhanced. Again, we are sitting in a scenario where the return on investment is higher at 21%. 21.71 is an average taken of the performance of the top 10 AIFs operating in the country. And if that is the rate at which the returns are taken, again you will see a IRR or even higher IRR of 39.27%. So the only point that we are trying to drive home is that the facility of leverage has further benefited the AIFs or made the AIFs operating in the IFSC even more attractive. So some very effective benefits for the AIFs in IFSC. Not just that, the keenness of the government to have AIFs brought into the IFSC can also be reflected from the different provisions that they have announced in relation to relocation of these funds. There are a few relaxations that have been granted. So a foreign fund may approach. So typically, if a foreign fund wanted to shift back, there would be a certain procedure of approvals to be required if the fund was to be set up and was to be again re-established in the IFSC. However, if a foreign fund is intended to be shifted to IFSC, a foreign fund which is invested into Indian securities, they may just approach the designated depository participant for approval of a one-time off-market transfer of its securities and to the resultant fund which will be set up in the IFSC. A very effective facilitating measure would obviously be quite attractive for funds who intend to shift into IFSC from a jurisdiction outside the country right now. Income tax exemptions have been, sorry, go back to the previous slide. Income tax exemptions have been provided in relation to foreign funds on transfer of any capital asset to an AIF Cat 1, Cat 2, Cat 3 in IFSC, again under 47(7) AC. So even if there is a foreign fund which is transferring into the capital gains, exemption has been provided. income tax exemption to the unit holders or shareholders of the foreign fund on transfer of. So there are two levels. When the fund transfers, there would be transfer of the security from the existing fund to the AIF set up in the IFSC. So in the hands of the fund, there is a capital gains exemption. Also for Cat 1, Cat 2, where there is some situation of a pass through, even the benefit, if any, arising or a gain any arising in the hands of unit holders will be exempted under 47(7)(a)(d). Exemption from tax on gains of subsequent transfers of the shares of the company resident in India on account of the resultant fund in IFSC under 23FF is also. So once the fund has been established in the IFSC, at the winding up of the fund, etc., where the transfer happens, those gains also which is arising have been given an exemption under 1023FF if it's a transition fund which is set up in the IFSC. So even from a relocation perspective, various relaxations have been provided to attract AIFs to be set up in the IFSC. So these are some of the regulatory benefits which are provided to the AIF setup in IFSC. Now let's touch upon the tax benefits which are there. When we come to tax benefits, tax is to a certain extent a bit of a maze when we talk about taxation in relation to AIFs and more so AIFs in IFSC. Of course, there have been attempt to make the AIFs in IFSC more attractive, and we'll touch upon that. I've given a summary of those. But before that, let me just give an overall picture. From an overall perspective, Cat 1, Cat 2 AIFs are typically considered as pass-through because of the facilitation provided under 1023 FBA, and therefore the taxability sits straight into the hands of the unit holders. The same thing, therefore, from an AIF, Cat 1, Cat 2 AIF sitting in the IFSC also, there will be no difference. It will be a pass-through. From a Cat 3 perspective, there will be, if it was operating in the onshore, the maximum marginal rate would be applicable depending on the nature of revenue that is generating, be it business income or capital gains. However, if it is operating from the operating in the AIF, there is an exemption from capital gains in relation under section 10(4)(d) on transfer of securities other than shares in Indian company on specified funds. And what is specified funds? Specified funds are those funds which is, of course, it will be a Cat 3 fund. It is registered in IFSC, and all unit holders other than, of course, the manager or sponsor are non-resident. So if it's a Cat 3 fund with all non-resident unit holders registered in the IFSC, it enjoys exemption from capital gains under 10(4)(d). Again, a very welcoming exemption provision which is made available. From unit holders' perspective, if they are under Cat 1, Cat 2, if they are in the landmass of the country, then whatever is a pass-through in the hands of Cat 1, Cat 2 becomes taxable in the hands of the unit holders. In case of Cat 3, again, in the normal course, it becomes taxable. So there is, in a way, a dual taxation. It gets taxed in the hands of Cat 3 also and in the hands of unit holders as well. However, if such unit holders of AIFs located in the IFSC, they would be eligible for capital gains. In case of Cat 1, Cat 2, they will be eligible for capital gains exemption if these are specified securities. Specified securities are specified under 47(7)(a)(b), and these are typically in the nature of ADR, GDRs, rupee denominated derivatives or bonds, foreign currency denominated derivatives, etc. There is a list of certain specified securities. If these are those securities, and subject to the condition that the transferor is a non-resident, that in the hands of a non-resident, recognized, this transfer has taken place on the recognized stock exchange in the IFSC, and the transaction is carried out in foreign currency, which it is bound to be if it is in IFSC, then it will enjoy a section 47(7)(a)(b) exemption. While it may seem to be a lot of conditions, typically if it's a Cat 1, Cat 2, which is operating in IFSC in relation to investment in underlying foreign derivatives or foreign security, there would be significant scenarios where all of these conditions would be satisfied and they'll be eligible for the exemption. Cat 3 unit holders will be enjoying an exemption under 1023 FBC, again in relation to specified fund, which is a fund which is enjoying an exemption at 10(4)(d), like we discussed in case of Cat 3. So that's the tax benefit from Cat 1, Cat 2, Cat 3 or unit holders perspective in relation to business income of capital gains or capital gains. Moving on to the next one, uh, in relation to again business income in the hands of AIFs, uh, if it is not in the nature of capital gains, but if it is in the nature of profits and gains of business or operation, and that would be a scenario where the underlying asset is Indian Indian shares or Indian equity. In that scenario, again, Cat 1, Cat 2 will be taxable under 1023 FBA, but it will not be taxable in the hands of the unit holders. In case of Cat 3, again, it will be taxable in the hands of the Cat 3 as well as in the hands of unit holders. The management fee or carry, again, both taxable in both the scenarios, Cat 1, Cat 2. But if the same thing is to be seen from an IFSC perspective, there will be a certain deduction available in under 80LA if the income is considered to be income from profits and gains in the hands of Cat 1, Cat 2. If it is considered to be income in the hands of unit holders, then unit holders, again, if it is exempted there, it cannot be taxed in the hands of the unit holders. In case of Cat 3 AIFs will also enjoy certain tax benefits under 80LA if it is considered to be business income. More important, very effective, is the exemption from management fees and carry. Both in case of management fees as well as carry, in case of Cat 1, Cat 2 or Cat 3, there is a clear exemption tax holiday for 10 out of 15 years available in the hands of the sponsor manager. This makes the setting up of the AIF attractive. This also results into the expense of carrying out or operating the fund lesser, and this results into larger residue in the hands of with the fund to be distributed to its unit holders. So net the tax benefits, while seeming like I mentioned earlier, it's a maze of various provisions coming into play, and all are conditional on certain aspects happening. The taxation of management fee and carry sits with no conditions, and therefore that benefit is clearly there to be captured by the AIFs which are set up in the IFSC. Next is a slide on certain withholding tax. I don't want to take too much time on this one, but withholding tax typically will flow based on the taxability as we've discussed earlier. So where there is a lower tax or an exemption available, the withholding tax would also be facilitated in that manner. Nothing significant except just one point I may highlight is that in case of Cat 3, where we see, I've mentioned none since section 1023 FBC, which is we saw earlier that there is a certain exemption available in the hands of Cat 3, and therefore the withholding tax also gets facilitated, which means the funds transferred by the Cat 3 into the hands of the unit holders does not undergo withholding, and therefore the unit holders tend to sit to be benefited to a significant extent by receiving larger cash flow rather than those being subject to TDS withholding tax provisions. Moving from the withholding tax related provision, this is just an overview of the different reliefs which I highlighted, but let's understand how do these impact. Dividend or interest income in hands of Cat 3 IFSC fund, which is typically the fund that would be set up and operating in the EIF, there will be a reduced rate of 10% under section 115 AD. Income earned by Cat 3 AIF from transfer of securities other than shares, we saw that, which is the specified fund, there is an exemption from tax, which otherwise, if it was operating from the AIF in the country, it would not have. Unit holders exempt from tax, exempt under tax under 1023 FBC. It results into higher return in the hands of the unit holders. The impact of the first two, which is the in case of Cat 3, would result into a tax benefit anywhere from 42.74% to 11.96, depending on the nature of securities that the Cat 3 has been dealing with, which would result into higher residue, which would result into higher NAV and carry. So both the unit holders are also benefited and the manager or sponsor also gets benefited, thus making it very attractive for AIFs to be set up in IFSC. Management advisory fee earned by investment managers. Again, we've already touched upon there is an exemption under section 80LA, and therefore higher management fees can be taken home with a lesser tax deduction on that. GST on management fees again sits exempt because this is in the SEZ, and GST exemption benefits as applicable to every SEZ will be available. There is increase. This also further shows increased return. Withholding tax benefits we've already discussed upon. Last one, again, very important. Exposure to P poem is in a way eliminated due to certain tax certainty being created. What was happening is that suppose if a fund was set up, say in a jurisdiction, in an offshore jurisdiction, and the manager or the sponsor of the fund was located in India, there was a possibility of the tax authorities alleging that the fund was being managed from India, and therefore it was constituting either a PE in India, the fund's PE in India, or there was a poem in India, which was resulting into effective management of the fund from India, and therefore the entire tax benefit which was intended to be gained would be brought to tax in the with the Indian authorities. However, with this whole fund moving into IFSC, mind you, from a IFSC perspective, like I mentioned earlier, from a FEMA perspective, it is a non-resident, but from an income tax perspective, the AIF fund does not become a non-resident, and therefore both the fund and the manager both will be considered to be in India, thereby eliminating the PE poem issue completely in case of these kind of transactions. So it also brings in a lot of tax certainty. Such tax certainty in turn would result into higher valuation, and because we've seen in a lot of negotiations that while bringing in investments, that tax certainty has become a very significant negotiation point while bringing in investment into AIFs. Those are certain tax benefits. Finally, I'm also touching upon a comparison between an offshore AIF and an IFSC AIF. An offshore AIF setting up an Indian focused fund in an IFSC versus an overseas jurisdiction. We have already talked about the poem and the PE risk which exists. I just touched upon that. There is also a GAR provision saying that there could be certain methods or certain procedures which could result into a constraint or a doubt as to whether any benefit, undue benefit, is being taken of the tax under the tax treaty or due to significant presence, etc. All of these get eliminated once the AIF is in the IFSC, since both the manager or the sponsor is in India and the fund is also in India. Like I mentioned, it could result into higher valuation of the AIF and a more attractive AIF than the one located outside the jurisdiction. Meeting with the substance requirement, in most jurisdiction there is a need for substance requirement. This also is being raised by tax authorities at the time of administering or assessing the profits arising from an AIF located in the other jurisdiction. And typically, more often than not, when an AIF is monitored, the establishment of substance requirements does become a concern in such situations. So that again gets eliminated. Tax advantage of fund managers, we've already seen. Even if you see fund managers operating in the really tax haven sort of jurisdictions, say for example Singapore, Mauritius, etc., the tax ranges somewhere in the range of from 3% or 5% to 17%. In Singapore, maybe a fund manager may be able to enjoy through certain structuring a tax neutrality, but a fund sponsorer would still be ending up with a tax of somewhere in the range of 5%. As compared to that, if the fund manager is operating from the IFSC, a 10-year tax holiday in the first 15 years is available under Section 80LA. Lastly, the exit convenience, since transfer of securities is undertaken by a resident Indian, withholding tax provisions would not apply, and therefore, Section 195 does not trigger. That's but thereby making it less prone to any controversy or scrutiny later on by the tax authorities. So that's from a comparison with the other jurisdictions. So this was on the AIFs, AIF setup in the IFSC. Lastly, I'll just touch upon the method of setting up an AIF in the IFSC. The process is, it may look to be a tedious process, but with the IFSC authority being proactive and facilitating setting up of these AIF, if proper documentation, everything's available, it's rather a cakewalk. So what is required is identification of office space in the gift city or obtaining NOC from the gift SEZ. You have a number of premises, and quite a few well-known developers have set up premises which is available at reasonable rates with enough infrastructural facility. Having identified that, you apply for a company or LLP incorporation for AIF manager or sponsor and obtain certificate of incorporation. Appointment of a trustee of AIF and the registration of the trust deed is required to be carried out. Once that is done, your base work is done, and then you apply to the SEZ authority for obtaining a letter of approval from the SEZ authority for setting up of the AIF, the AIF manager, or the sponsor. Uh, Having received the approvals from the SEZ authority, you make an application to the IFSCA authority in the GIFT SEZ for issue of letter of allotment for allocation of space. Based on which you go to the developer, and the developer provides you the space, you enter into the lease deed, etc., and your office is up and functional. Lastly is the application to the IFSC authority. A specific format has now been issued very recently for the constitution of the AIF with the IFSC authority. Like I mentioned right up front, that the unified regulator IFSC authority will now be in charge of all of these AIFs. Even the grant of the certificate of registration for the constitution of the AIF will be done. The form is somewhat similar to the form applicable to be filed under the SEBI regulations of 2012, and again, you need to categorize whether you are a Cat 1, Cat 2, or Cat 3 AIF being set up in the IFSC. Once the AIF has been set up, you can commence operation of the AIF. Last couple of slides on what are the parameters to be kept in mind while setting up an AIF. These are quite similar and identical to the SEBI regulations of 2012. The only difference is that these are all in foreign currency, and the quantums also, after applying the conversion ratio, is almost the same. It comes to the same quantum. So for sponsors managers, a sponsor manager of an existing AIF in India can act as a sponsor manager of an AIF in the IFSC as well by setting up a branch or incorporating a company, which we already spoke in the previous slide. Sponsor manager to be set up in IIF need to incorporate a company or limited liability partnership in the IFSC. Various other criterias of minimum investment by the continuing interest by the sponsor or manager in case of Cat 1, Cat 2 being 2.5% of the corpus, or 750,000 USD. In case of Cat 3, it will be 5% of the corpus, or 1,500, so 1,500,000 USD, whichever is lower. The manager or the employee or the fund manager has to be with appropriate qualification with past experience of more than 5 years, as are the provisions applicable under the 2012 regulations itself. Appointment of custodian will need to be undertaken. Again, the corpus fund will have to be more than 70 million, which again corresponds to the relevant quantums under the Indian. So under the Indian rupees, if it was an onshore, it is 20 crores. If it's taken into an exchange rate, it would approximately come to the same amount. Trusteeship company, certain provisions, corpus requirements, each scheme of the AIF to have a corpus of at least 3 million. And sorry, that is the 20 crore requirement. The corpus of the AIF would be 70 million, which is the custodian. And the tenure of the corpus will be minimum 3 years for category 1 and category 2 AIF. Category 3 could be an open-ended AIF as well. Lastly, few more aspects. Eligible investors, again very important. Eligible investors in case of AIF in IFSC can be person resident outside India, non-resident Indians, institutional investor resident in India, eligible under exchange regulations to invest funds offshore. So typically, most of them are eligible unless there is a default or some other action that taken by the regulator. Also, person resident in India and having a net worth of USD 1 million. This net worth criteria is coming from the SEBI regulations. Having a net worth of 1 million can in the preceding financial year can also invest through the LRS route, subject to conditions of the LRS as are applicable in the normal course. So the minimum investment by an investor would be 40,000 USD. Will be 150,000 USD. In case of an AIF manager or director of the AIF, it can be up to 40,000. Minimum investment is 40,000 USD. Currency will be foreign currency to be done. However, the AIF may be facilitated to operate Indian currency accounts as well, only to meet with administrative expenses for the functioning of the AIF. So these are certain parameters in relation to AIF that brings us to our discussion on a larger IFSC piece, the AIF within IFSC. Lastly, just a few food for thought. SPACs, which is today a very hot topic. There is a consulting paper issued by the IFSC, and they are looking at bringing in SPACs into the IFSC, experimenting with SPACs in the IFSC. It's just a matter of time. It has been put for comments, and comments are awaited. Variable capital companies, which is currently prevalent in Singapore and got approved on the 1st of October, while in the budget of 2018 in Singapore, where investments which could be variable investments for capital which does not need to be a permanent capital can be brought in, or multiple funds can be operating under the same company, is also being looked into and thought over by the IFSC. In fact, a specific expert committee has been created to look into the same. Uh, so, like I mentioned earlier, the IFSC authority is quite proactive, looking at innovative aspects to be brought in, and looking at further development and making IFSC a really attractive destination. With that, I come to the end of our presentation. Thank you very much for your patience. I missed out to mention that we are, as ELP, we are a full service law firm. We do have an office in IFSC as well earlier, and we are right now, as we speak, catering to a number of clients in helping them setting up EIF as well as various entities in aircraft leasing, etc., within the IFSC. I will be joined now with my partners Rahul Charkha and Pranav Pagaria to answer to any queries that you may have. There are a few questions that I see.
Sure.
Rahul, Pranav, you all want to take up some of these?
Sure. So I think we are running against. I think we've already overshot our time. But couple of important questions, if I may pick them and maybe shoot one or two, which we can collectively answer. So one question is regarding the PAN requirement for an investor in IFSC AIF. Yes, the provisions have been relaxed. Of course, there are some conditions. The key ones being that it should be a non-resident investor, and the non-resident investor should, the only income that the non-resident investor is earning in India should be out of this AIF. If those parameters are fulfilled, then there is no requirement for either obtaining a PAN or filing a return of income in India. Of course, the third major or an important criteria also is that appropriate withholding is required to be done by the AIF, but that anyways would be an obligation of AIF which would be carried out. So subject to fulfillment of this, the PAN requirement, in fact, it's a welcome change announced in the budget, uh, and it's brought in a lot of compliance relief for the investors. The second one, again, if I may pick up before reaching out to Nishant and Pranav, is can an existing AIF be transferred to IFSC if it is in an investment mode? Well, and Pranav or Nishan can throw some more light on the regulatory bit, but at least the tax provisions, so far as the tax neutrality of migration of AIFs is concerned uh, into an IFSC, it does not specify the stage or the phase at which the AIF is at currently. Of course, there are certain other conditions prescribed in order to achieve a tax neutrality for such migration, which needs to be satisfied.
Right. So, Rahul, just to add to this from a transfer perspective, regulatory perspective, as we've discussed during the course of this presentation, that there are certain restrictions on the Indian investors investing in a AIF within IFSC. So to speak, the LRS scheme, where there is a $1 million requirement for the net worth. So if the AIF is currently in the investment mode, during that period, there would be certain investments from the Indian investors. And if those do not meet the requirement of an AIF in IFSC, possibly those could be some practical challenges that we may have to deal with in transitioning a domestic AIF to a IFSC AIF.
Right. Also, the current regulations provide for two levels. So, I'm not sure at what level of this AIF is, because post the in-principle approval by the authority, the AIF can start garnering commitments and not collect the money. And post the final certificate of registration being granted, the monies can be collected. So if it is at a stage where only commitments on investment have been taken, there may still be a flexibility as against what Pranav just highlighted, certain concerns that may arise.
Right. Right. So I think we are about time, but if we can just take one last question, and maybe Nishant, this one is for you. It is the first part of it. That if you know how I mean, what would be the impact on IFSC AIFs if there was to be a change in the political situation in the country, be it a change of government or any external factor as such? What's your views on that?
Yeah, so I think a very important question, because a lot of these schemes have at times been politically influenced, and with a change in political authority or in change in the central government, we may see certain implications. However, right now, the manner in which the legal structure has been put in place by having the IFSC authority, which is constituted under a separate legal statute, there may be a possibility of stating that so long as the authority continues to hold the powers and continues to drive the development of the financial products, services, and the units within the IFSC, I don't see a reason for units to be set up there to be concerned in any manner. In addition to that, typically the concerns of AIFs have been these ambiguities on taxation, etc., or regulatory aspects, which from an IFSC perspective, the legislation so far have made things quite clear. So, if the things were to change and political will was to be the other way around, it's difficult to say what the future would be like. But as of now, the manner in which the legal framework, etc., is, I would say that the IFSC is likely to become a really attractive destination for investments to come.
Yeah, right. Sorry, and I think just one last shot before we part, because I think we've overshot 15 minutes. But there's also a question on, should the custodian be mandatory from IFSC? Uh, I believe that in case of IFSC, such custodian has to be a branch in the IFSC. So to that extent, a presence in IFSC is required. But Nishant, Pranav, any views or
Pranav,
thoughts
could
on
Yeah,
you?
that?
so I think this question, I mean, if I'm understanding correctly, is intended to understand if you are a unit or a AIF within IFSC, is it mandatory for you to have a custodian? The answer to that is that it is the replica. The provisions are replica of what they are in the domestic AIF front. So if you are breaching certain thresholds, then it is mandatory for you to have a custodian.
Right.
That's right. Right. So there are more questions pouring in, but maybe I think for paucity of time,
Yeah.
it'll
So,
help if
like
you
we
can
said,
write.
right, Rahul. So, like we said, that our coordinates are there up on the screen. Maybe request if you can drop in an email to us with your queries. We shall be happy to respond to those. Unfortunately, we've been running out of time. Like I mentioned at the start of the presentation, that IFSC itself is a pretty large topic, and straight away going on to AIF would not have given justice to the authority and the philosophy of IFSC. So I had to touch upon that, and then we've touched upon the specific aspects of AIF, considering the interest of the participants. We will be happy to respond to your queries. Request you all to please email us at the coordinates on this on the screen, or you may send it to IVCA and they shall pass it on to us, and we'll respond to those queries. Thank you so much for your time, for being patient and listening to us. Take care and stay safe. Thank you.
Thank you, everyone.
Thank you. Take care. Stay safe. Thanks.